Okay, I think everything's set up. Had a lot of moving parts there on the screen. Let's make sure we have a different court reporter this morning. Nope, I'm confused. They look like there are two people sitting in the court reporter space.
Ryan. Yes, sir.
Do we have two court reporters? We only need one transcript.
Hi, Judge McBurney. This is Joan Drame. We're with Taggart Court Reporting. I have a fellow court reporter here who is going to be taking down today.
You're just going to watch?
Yes, sir.
Okay. We're only paying for one court reporter, though?
That's correct.
Okay, excellent. Well, I'm happy. Whichever one of you is at the keyboard or whatever it is called, you use the stenography machine, that's great. If for some reason you cannot hear what's going on, wave your arms, do something so that we know that there's a technical issue. But otherwise, we're ready to roll. What Ms. Drame was doing yesterday was just the thumbs up. When I would ask a yes or no question, thumbs up meant yes. Thumbs down, no. I don't ask lots of questions to the court reporter, but every once in a while we do need to interact, and I try to keep it to yes or no so you don't have to mess with the mute. Are you ready? Yes. Look at that. Okay. Good. Gonna mute whatever machine that was. Okay. Oh, and one other thing. Looks like we have someone on from pretrial. Today is not going to result in any activity that would require input from pretrial. So if you want to roll off to do other things, that's great. You're welcome to stay on. But I don't think we're going to need anything from pretrial today. But I appreciate you all, as always, joining our criminal sessions. So let's get on the record. It's 24 SC 005809, State versus Marvin Gentle. Mr. Gentle is here in court with one of his lawyers. Ms. Clark is here for the state, and we are going to talk about any number of motions. The defense has landed hard with 23 documented motions or notices. Maybe that's how they roll in Cobb, but this was new and different to me. Some of them, frankly, are unnecessary and are filling the docket with paper. Others, we need to make sure that we work through and resolve before we get this case to a jury, if in fact that's how this case works out. I identified a few of the many that I wanted to cover today, but I don't want us to break and end today if there are substantive matters that we haven't at least touched upon. We might have to set another date for them, but I do want to make sure that our next stop is either a final motions hearing if we don't cover everything today, or final plea in this case so that we're moving it forward. So if first I could have counsel for Mr. Gentle.
Kyle
Densler?
Denslow, D-E-N-S-L-O-W.
Great, Mr. Denslow, thank you for being here. I want to start, I promise we're not going to go through 1 through 23 because we're taking the trial down. We don't need a motion for complete recordation, things like that. A call up on the screen for me. Offense. Well, gosh, it's going to be hard to find them. Let's see. What's listed as number 1 in the motions index, the notice of objection to state's notice pursuant to 902. That's a new one to me. oddly combative. 902 is 902. But why don't you, Mr. Denslow, let me know what's going on with number one? And I'm going to see if I can find it in the docket. Some of the labeling is real clear and others, and it's the clerk that labels it, not you all. Yep, I did find it. So your number one objects to the state's notice relying on the rules of evidence that hopefully we can all rely on throughout these proceedings.
Judge, and I understand, and I want to make one kind of cursory statement because I get 23 motions is not maybe typical here. And I want to just tell the court that Ms. Fry and I, when we go through our motions packet, each one of these is due to a specific thing that's happened to us at trial. And in particular, Judge, some of these that may seem kind of unnecessary, and I don't want to argue with the court about that. I understand your perspective, is also for, nobody plans to lose a trial, right? But when we go up on appeal, the Court of Appeals and the Georgia Supreme Court, arguments are much stronger on appeal when they're raised at the first opportunity. Mm-hmm. So I always try to make a record at the earliest opportunity. So that's part of it too. Got it. But insofar as that particular motion, Judge, the thing that I see happening with business records, and my last trial is a great example of this. How about this? Are there business records in this case to which you're objecting? Does the state have any business records they intend to introduce in this case? Because if not, we can just move on. Okay.
Yes, we'll have business records, Your Honor. What I can think of right now, the CAD report and the 911 call, you're gonna have a business cert for that. You're gonna have hospital records.
I could call those medical records?
Medical records.
Okay.
Yes. Sorry.
That's all right. No, but I just want to make sure that it's not records as like, here's our profit and loss statement, but it would be treatment records for the alleged victim in the case.
Correct. Yes,
okay.
Sir. That is all I can think of right now, Your Honor.
Not bank statements, not phone records. What we typically see in criminal cases outside of the white collar unit would be the two you mentioned, something from APD or the law enforcement agency, not a police report, but the administrative CAD report, 911, medical records, phone records, and occasionally their bank records. But it sounds like no bank records, no phone records. It would be things from a hospital and things from the 911 call operations center.
Yes, Your Honor. There was a phone extraction done in this case, and I have not had an opportunity to go through it fully to see if that would be, but I know that we possibly will have a business record for that if I need to introduce that. But
I don't know that would be business records. So the state law enforcement obtained someone's phone, put it into Cellbrite or whatever it's called, and got an extraction.
Right.
Okay, that's not a business record. That'll just be a report generated by law enforcement. Someone will need to testify about how they got it, what they did, et cetera. And that certainly was prepared in connection with the investigation as opposed to a business record in the ordinary course of business. So you'll figure out your own way to get it in. I don't think motion one from the motions index is addressed at that. So, Mr. Denslow, assuming, and you're waiving nothing here, but assuming the universe of business records would be medical records where there's a certification from a custodian from, I'm going to pretend it's Grady, wherever it was, and then a certification from the custodian at Atlanta 911 or Roswell 911, wherever it was. Here's the CAD report and the 911 call. Any pretrial concerns, not about the contents of that evidence, but having those authenticated by way of 902?
I guess my greater issue, Judge, and it's part and parcel to this, is I need a witness. I mean, like for instance, the example I was going to give the court from my last trial was we had receipts from a bar, right? Those receipts looked very inculpatory. When the witness got there and testified about those receipts, they became much more, if anything, exculpatory or neutral. I can neutralize that with a witness. So I suppose I could subpoena them, but if the state wants to bring this evidence, I think they should bring all of it. So
let's take medical records. Mm-hmm. Presumably there's going to be a doctor or a SANE nurse or someone who will be testifying, but that person didn't generate the records. The records are kept in the ordinary course of business at Grady. There's a records custodian who would have generated at the state's request from their subpoena or whatever it was, a stack of records, which you ought to have too. If you don't, part of what we need to cover today is why don't you have these things yet, state? But assuming you've got the medical records, I would not expect that anyone would require, they could, but the rules of evidence allowed us to avoid that now, would require a custodian to come in to say, there was a request for records relating to the treatment of person X. I go to the computer, I press some buttons, and it spits the records out. So if your concern is, hey, these shouldn't come in a vacuum and the records speak for themselves, I agree with you on that. But if your pushback is, no, they need to bring someone in to prove up that the records are what the records are, I think the rules of evidence, if complied with, and if your pushback is that that's not a valid affidavit, or I don't think these were kept in the ordinary course of business because they're medical records, and then there's some doll attached to it. Like, well, that's not ordinary that they would include with it something that's not normally there. But that's not what I'm hearing from the state. It sounds like the CAD report's the CAD report, medical records are that. Is your concern there should be a living, breathing person narrating the records, but not authenticating the records?
That is the concern, Judge.
Okay. I don't think 902 objections get at your desire to have a witness who will be narrating the records. I think that's a good conversation to have with the state. I would likely not, I don't know that I would admit as relevant medical records if there wasn't someone who's going to be talking about them. And so that would be the tie-in. Because otherwise, I guess at the end of the trial, the state would stand up and say, oh, we want to also admit states 99. What's that? 400 pages of medical records. Well, no one's talked about them at all. And well, Judge, they're the records of treatment of the alleged victim. Okay, but no one's talked about them at all. And so running into that, so receipts falling from the sky, I think I hear your concern. The types of records the state has described, I don't see that as how this is going to play out.
I don't disagree, Judge. I think if that's how this is going to go, then we've resolved this issue.
Okay. I'm not denying it. I'm going to say that we'll revisit motion 1 should the need arise, but I'll look to you, Mr. Denslow, to flag that. And I encourage emails to Ms. Nelson. Copy Ms. Clark, but hey, we thought we had taken care of number 1, but we just got receipts from a bar and a little affidavit saying these are receipts from a bar. And man, I can't find anyone on the witness list who looks like he or she would be talking about receipts from a bar. Not this case, but I don't mean in pushing back at the outset of this session to say I want to in any way undercut your ability to protect your client's rights and vigorously defend his case. I just want us to be as streamlined as we can be. So 1 will be deferred and readdressed only if needed.
The next one, Judge.
Well, next one I want to talk about, we can go back to others if you have questions. I understand 12 in a box. That's not how I do it here. That's not how I'm going to do it here. But we talk about that when we get to, if this case goes to trial, talking about voir dire before the jurors come in.
So I'll just, for my note taking, I'm just going to put deferred.
Deferred. Okay. 2 is deferred.
Because I do want to make a record about that, Judge.
Okay.
When we get to it.
The time for that would be if we're picking a jury.
Absolutely.
3, the state shouldn't burden shift. And if they do, you'll need to make a contemporaneous objection if you think they are burden shifted.
And Judge, and I'll keep it brief. The reason for that, and this is a great example because today we're talking about in-camera inspections. I don't have the same subpoena power as the state. And so oftentimes I see that in closing when there's a piece of evidence that we're talking about is missing, right? The state didn't show you this, and we think this is really important to guilt or innocence. And the state responds, well, they have the same subpoena power as we do. And I don't, because here I am. She can subpoena those defects records. I cannot.
Well, you can. You just go through me. I get defects records all the time for the defense. I get a petition from the public defenders in this courtroom saying, we'd like the defects records in connection with X. And I get those, and there's an in-camera review, but just happened this week by my staff attorney, and then she lets your counterpart in that case say, hey, if you want to come look at this, here of the 80 pages we got, and all 80 will be made part of the record if there's an appeal. But of the 80, here are the 20 that relate to the allegations in this case. And then the defense attorney can look at them. In fact, I've had trials where the defense attorney says, well, I want to talk to you about these defects records. And the state jumps up and says, what defects records? Didn't go well for the state because, of course, they could have gotten those.
Right.
Didn't go so well for the defense because they didn't share them as something they were going to use.
Right.
But the point is they had them and the state didn't. So again, I don't know how it works in other jurisdictions, but if you are anxious to get defects records, you have a way of doing it. Not with a subpoena. You're right. You don't have subpoena power, but we would have to have a sidebar if you push back. If the state said in closing, the defense could have obtained these things that they're saying are missing. That is a true legally correct statement. If what the prosecutor said was the defense could have subpoenaed them, the prosecutor was sloppy in making that argument because no, you couldn't subpoena them, but you could get them.
And Judge, that's just one example, but there are others. The truth is, I can't use a grand jury subpoena. There's many things. The subpoena power is not even between the state and the defense. It's not an accurate statement.
And the state shouldn't burden shift. And I don't know what to say. And the state also can't invoke the golden rule. And you can file a motion in limine about that, but it doesn't change the impropriety of the state doing that. And I don't know, you could file 1,000 motions in limine, but if you didn't object during trial, it's not going to go real well on appeal. Yeah. So I understand that you said some of this is to start to build the foundation should trial not go well for my client so that an appellate court can't say, you brought this up too late. Some of these I think are coming up too early, but all I'm saying is, yes, the state cannot burden shift. And if you know, as we get closer to trial, that you've been talking with Ms. Clark and she keeps alluding to something, then we can have a more particularized motion in limine before trial or even before closings as you've gone through the trial and you've heard things. I'm happy to have these kinds of conversations when we can link them to the substance of this particular case. Like we did with number one, where then Ms. Clark said, all right, these are the business records. And she didn't say, we've got these receipts. Well, we're going to need someone who can narrate those.
Thank you, Judge.
All right, that's number 3. Number 4, everything will be taken down. Number 5.
Judge, if I may, that's including voir dire openings, closings.
I have court reporters take a court reporter. Here we have 2 today, but take down from voir dire to closings to include the charge conference, assuming that's what no one has to ask for it, but as an example, sometimes we do the charge conference. We end at 4:30 one day, and I'm comfortable excusing your client. And I'll ask everyone, do you want it taken down? If you want it taken down, that's fine. Court reporter knows she's got to stay here. But there will never be, oh, I didn't realize that wasn't being taken down. The default is takedown. If it's not going to be taken down, it is with your waiver of the right to take down.
Thank you very much, Judge.
You're welcome. Number 5 is a motion to exclude reference to the complaining witness as a victim. I'll let you argue it if you want. I'm going to let people refer to people. Your client may be referred to as the defendant by the prosecutor, and they can refer to the person as the victim. I won't. I will say alleged victim, but I don't preclude witnesses, whether it's law enforcement or whomever, or the prosecutor from referring to the person that they have identified as a victim, in this case, as the victim.
Judge, and I think that would be different for the state in argument, right? Because they are arguing that this individual is absolutely a victim beyond a reasonable doubt. That I don't think I have a legal leg to stand on at all. Insofar as even law enforcement witnesses telling the jury that if he's a victim, that means Glenn's guilty.
Yep.
So that is absolutely telling them what their verdict should be from the witness stand. That's my problem.
It is a problem for the defense, but it's not legally improper. It is not unduly prejudicial. It's what law enforcement calls. That's the suspect. That's the accused. That's the person I arrested for child molestation. I arrested him because I thought he molested someone. And an officer could say that if you ask the wrong question. You won't ask that wrong question. But you're making a record, and my ruling is that witnesses are not precluded from referring to the alleged victim in the indictment as a victim. I will say alleged victim in my jury charges, in my interactions with the jury, so it won't be coming from the judge. But the state won't be prohibited from saying victim. The state won't be prohibited from pointing at your client and saying he's a child molester. That's what they're going to do. And you're going to explain to the jury, if this goes to trial, why they got it all wrong and this is a terrible misunderstanding or railroading or a framing or whatever the defense is. I am very unfamiliar at this point with the facts other than the basic allegation.
Judge, insofar as from the court, more of a request, but I don't know if you would be willing from the court to refer to the witness as the complaining witness as opposed to the alleged victim. I don't know if that's something the court's comfortable with, but I would make that request.
Okay. It's not a lack of comfort as it is awkward phrasing. And I do my best when interacting with the jury. And if we do get to trial, you'll see it in how I work on jury charges. I resist inaccessible jury charges. If it is legalistic, I'm going to try to make it in English. And so complaining witness is like exiting a vehicle. I get out of my car. I don't exit my vehicle. A cop exits her vehicle. And so I'm not going to say, today I exited my vehicle and hit my head. That's why I have a bruise right here. And so I'll do my best to always have the word alleged in there. But complaining witness is a creature of the combatants in this process, but not lay people. So appreciate the request. I doubt you'll hear me say it. All right. And Ms. Clark, I never mean to skip over you. If I feel like the ruling isn't one that the state would be comfortable with, I'll hear from you. And you should always interject if I move on to the next one. Wait, Judge, I want to make a point for one of these. Okay?
Yes, ma'am. Thank you.
All right. So I'm going to defer number 6 till before trial. This is excluding personal information. And I suspect the answer is going to be, it depends on the personal information. But that's context specific, and I'm deferring number 6 to trial time. Okay. Number 7, let me find that one. So the way I read this, Mr. Denslow, is you would like hearsay excluded.
Correct.
Okay, I agree. Hearsay shouldn't come in. No such thing as a blanket objection. So I intend to enforce the rules that prohibit hearsay, but also the ones that create exceptions to hearsay, like child hearsay exception. And I'm happy to litigate those as those arise. But again, not so familiar with what happens in Cobb. This is not a hearsay amnesty space. As long as you're objecting to it, I intend to exclude it. If it's a statement being offered for the truth of the matter asserted, even if it's something that the witness on the stand said out of court, that's hearsay. That's often a disconnect, in particular for prosecutors. But Judge, this is the person who said it. Okay, that doesn't mean it's not hearsay. Did this person say it outside of court? Yes. Are you offering for the truth of the matter asserted? I am. There may be another reason why it comes in. Jurors don't like it, and I discourage lawyers from objecting to hearsay when it's here's what I said outside of court, but I don't discourage them in front of the jury. But I intend to apply, as best I understand them, the rules of evidence concerning hearsay, its inadmissibility and its admissibility. I just looked over your motion. It doesn't have a specific concern, as in we know that the mom's going to come in and she's going to say, hey, the aunt told me, and that's key to the case. You know about something like that in advance. Let's definitely have a revisit to this with, here's a specific one I'm concerned about. Obviously, there's the child hearsay scenario. If in this case, and I can't remember, if the alleged victim told mom and uncle and a school counselor and this and that. Those are likely coming in, assuming one, the victim's going to be testifying, and two, the other requirements are met. And we can talk about that, but other hearsay, if you know in advance that there is an issue, I'm happy ruling in advance. That may not happen. If it gets teed up in this particular way, Ms. Clark, make sure that this person's not going to blurt it out, because Ms. Clark's not going to ask if I say, let's not go there, but there may be a witness who really, really is dying. And in cases like this, it gets that way.
They are.
And so I need the jury to hear this. And so the state asked an innocuous, and then what happened? That's when the aunt ran into the room to say, blah, 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 blah.
And Judge, I'm sorry.
No, if you have a legitimate concern that we've got a witness who is going to get swept up in the moment like that, I'm fine, not only one, granting your motion in limine in advance so that Ms. Clark needs to stay away from it, directing Ms. Clark to tell the witness to stay away from it, and if we have any slippage, telling the witness myself outside the presence of the jury, do not X. And if you do, there are going to be problems for you. And I don't mean to get Ms. Clark nervous that I think this is a case like that. I don't know that it is, but no one wants a mistrial.
Absolutely not.
And so that's why we'll be careful around this.
And Judge, you nailed the reason why this is kind of in a more blanket posture, and you nailed it, hit the nail on the head. It is because, in part because the type of case it is, and a lot of times there are subsequent disclosures that may or may not make it to me. And I want to be very clear, I'm not trying to disparage Ms. Clark in any way, shape, or form, but you hit the nail on the head. What we're asking for is an order that, either an order or even if Ms. Clark just wants to represent it from the state, I'll take her at her word that she's going to instruct her witnesses prior to them taking the stand to not go into inadmissible hearsay, to avoid those flirtatious, accidental things. Because just like you said, jurors don't like objections. They don't. And I want to object. That's part of the reason I do this too. I want to object as little as possible during this trial.
I get it. And that's obviously case specific and witness specific. So we'll see how that flows. The way I'm going to handle it is, of course, yes, we're excluding hearsay when it's objected to. But I'll again invite you that if you foresee leading up to trial that there's a particularly fraught area for any number of the witnesses, then I'd start by then exploring that with Ms. Clark. And she may say, I'm aware of that as well, and here's how we're going to skirt it. And I'm often very welcome and permissive with the state leading when we're around that area. And you'll need to be tolerant of that, because otherwise you'll be objecting.
Yeah,
and I'm like, no, I'm going to let her do this so that she could say, all right, you just told us this. Did this happen next? So that we sort of leapfrog over or protect against the inadvertent blurting out of that's when the aunt said X.
And I am totally on board with that, so long as if we can earmark that beforehand.
Right.
Perfect. Excellent.
But that's going to flow from you. I'm not going to know that witness X is at risk of blurting something like that out. You'll have a better sense, but the best sense will come from Ms. Clark. She doesn't want a mistrial either. So we'll work collectively on that. Again, with the huge exception being these witnesses will likely be saying, and here's what's the name? How are we referring to the alleged victim in terms of, are we using initials, last name? When you're going to be presenting to the jury?
I'll refer to him as Logan.
Logan, okay. People will be permitted to talk about what Logan said to them, not about all of life, but in terms of disclosures. That one, but you'll know that's coming, and you'll object however you want to object. But that's the one area where I don't expect there to be this careful cabining.
Assuming I have all those statements in advance.
Right, right. Well, I assume we'll get to this, but the state needs to identify which witnesses are they have to be identified in advance. And that way, none of us is surprised by, and then Logan said, there'll be buildup for that, but still, there shouldn't be a witness who starts to talk about Logan's disclosures, and you were unaware that that witness was going to talk about that. And I'm also open, when you get that list, to a defense concern about cumulative. Do we need 40 people coming in here saying Logan was so upset that next day? to provide context as to something must have happened the day before, because we all noticed how upset he was and he said X about it. We don't need 40, but we may need more than one. So we'll strike the right balance.
I don't foresee that being an issue, but I agree.
Okay. All right. Number 8 is something about, it's a motion about precluding certain of the statutory questions. I'm deferring that until we get to voir dire. I will be sharing with counsel on both sides the general questions. The way voir dire works in here is that you'll be given an opportunity to send to me in advance of trial. These are the questions we want to ask. On the eve of trial, I will send you back the questions that I will be asking all 51 jurors, however many we have in here, where they respond only by raising a card. And I have my own distillation of the 3 statutory questions into one. You'll see it. We'll have a chance to talk about it before the jurors come in so that you can say, I don't like it. I'm fine with that, whatever. You'll also be able to argue about adding questions to those general, because I will have excluded some of yours, I promise. And it's nothing personal.
I'm never surprised.
Voir dire does not need to last 6 days. I was spoiled in federal court by the judges doing all of it. And we would get a jury in a triple murder. Didn't do a lot of murders up there, but it'd be a complicated case in 2 hours because it was just the judge. We'd be like, wait, could we? Nope, can't ask that. Could we? Nope, can't ask that. But it works differently in state court. But we'll get a jury in 1 day. You'll have a chance to argue to include more or to remove these general questions. When it gets to individual voir dire, you do that, I don't, but you don't get to then inject your topics. If I said, we're not going to ask the jury their views on legalization of marijuana, say that was one of the ones you submitted, and I struck that. Judge, we think you should ask that. I'm not going to ask that. The fact that I didn't ask it means you also don't ask it during individualized voir dire, with the one caveat that if the guy says, my job is cannabis for Georgia, then you get to ask him all about that because that's his job. That's a way to backdoor it in with that guy. And backdoor is the wrong term. That's his job. Well, what are your views? Like, how'd you get that job? What do you think? But the next juror, who is a janitor, you don't ask him about his views on legalization of marijuana because I said that's not relevant to what this case is about. But we'll cover that later if there is a trial.
Understood.
Number 9, I don't know that I can get you a separate workspace.
Okay. And I want to just clarify too. I mean, this is, if there's a broom closet, I will take the broom closet just simply because breaks, witness occasionally as trial unfolds, witness interviews, being able to put witnesses there. So literally a room with a door. Any room with a door would be.
That's not the restroom.
That's not the restroom.
Right.
I don't think that would be a good idea.
Well, that's a public space. I understand the request. It's something that you should renew at the time of trial because there are possibilities. It depends on what's going on in adjacent courtrooms. There are some shared spaces. If someone got there first or is using them for alternate jurors, you fall in line behind those uses. If those spaces aren't being used, then great, they're just sitting there and they got doors and you can certainly use them, but it might not be a forever space during the trial. It would be today you can use it. I don't know if tomorrow a judge is going to need it for alternate jurors. So you wouldn't want to unpack and put a pillow in there and put posters on the wall. But you could leave your stuff there overnight. It just might be at the start of the next day, you got to pull it out.
I understand, Judge. And again, I call this the away team motion because we are the away team everywhere we go. And the state's the home team everywhere they are. They have a whole floor.
It is a reasonable request. And I have been involved in long-term trials where we necessarily have to do that because you got all these boxes and there'll be days off from trial. And I need that table back during those off days. And it can't be your encampment. So fair request and we'll accommodate as able. Number 10 was one I had on my list, which is exclude references to prior bad acts, arrest, or convictions. Are you aware of things that the state should stay away from? / this is assuming your client doesn't testify and say, I've never been in trouble before.
Right. Absolutely right. And Judge, the way I like to handle this one is the same as with stuff like business records. If the state doesn't intend to introduce anything, then we're done here. So if Ms. Clark, do you have any prior bad acts or anything like that?
So I'll ask, and I'm pulling up the motion first. So Ms. Clark, you had a very late filed 414 in a different case, but you helped me understand why it was so late filed, as people only now are more comfortable talking about things. Do you at this point have any inkling that there would be 413, 414, or 404B in Mr. Gentle's case?
There is one, Your Honor. There is a solicitation arrest out of Glenn County. But I need to interview witnesses to get an understanding.
Okay. Would this be adult situation?
No, it was the defendant soliciting an undercover officer.
Okay. Who was portraying him or herself as an adult?
Correct.
Okay. All right. You should explore that and then certainly keep Mr. Denslow in the loop, and then we'll revisit this. But in general, things like prior bad, well, first of all, there need to be notice and a hearing if there are going to be any prior bad acts or other acts, as we call them. And then if you're going to use a conviction to impeach, you need to provide notice of that. I guess you would hopefully know, Mr. Denslow, if there are any convictions out there. What I heard Ms. Clark say is that there is an arrest from long ago and far away. Doesn't make it irrelevant, but it may be a little attenuated. Are you aware of any convictions?
No, Your Honor.
Okay, then that one, it seems like you can not lose sleep over because there aren't convictions. And we'll rely on the state in being timely with any notice it's going to file in terms of other acts. Sequestering law enforcement witnesses.
Judge, this is another one where if the state intends to have the lead investigator at counsel table, if they don't, then I don't have it. Then there's nothing to argue about.
Okay. Ms. Clark and I haven't had a lot of trials, but I'm thinking through, that hasn't happened in a long time for anything the DA has done, having they have a DA's investigator who flits in and out of court because that person is making sure a witness is here or bringing, hey, this is the evidence for today. But I haven't had a police officer sit with a prosecutor, I don't know if ever since I've been here, but I know the issue. It comes up, and it happens federally a whole lot because the lead agent wants to be right there. It's almost like it's a job requirement for them. But the case law is pretty clear about that. You don't intend, Ms. Clark, on having anyone other than a trial partner sit with you?
That's correct, Your Honor.
Okay, then that's moot. Number 11 is moot. The sequester all witnesses separately. I will invoke the rule. I'm not going to require the state to find different rooms if they happen to, because they're going to not want to make us wait too much, have 4 witnesses who are available and ready to go in succession. I'm not going to require the state to have them be in 4 different holding rooms. They may be the home team, but they don't have a hotel that's empty. But I'm happy if you remind me to instruct Ms. Clark, to instruct her investigator, to instruct the witnesses to not talk about the case. And of course, you're free to ask these witnesses, hey, before you came in here, where were you? And who were you with? And did you guys talk about the case? You know what they're going to say, but you're free to ask that. But I'm not going to require the state, especially if we've got a day when it's going to be quick touches, it's 10 witnesses, and so they have to have them all here at once. They may well be in the same space. They need to not be talking about the case, and I'm happy to provide that instruction.
And Judge, obviously, this is not so much to do with me thinking the state is going to try and pull a fast one as much as it is out of experience, lay witnesses saying, oh yeah, we won't, and then they do anyway. And Judge, again, this is from my last trial. I call this the TikTok rule. We all found out together about a TikTok that happened while crossing the street in a vehicular homicide case. Very relevant evidence that state was partially aware of, I'm not sure. And the 3 young girls that were all eyewitnesses to the accident discussed that while they were sequestered. So one witness, after they finished testifying, came back to the same room. Mm-hmm. So even if it's just a matter of once they're excused, they can't go back to the room with the other witnesses.
Sure. So let's talk about that at trial time. That last request makes a ton of sense unless because there's family here, it might be that when witness one is done, witness one says, well, my brother and my mom and my so-and-so, I can't leave. I came with them. But it could be that what they do is to stay in court and not go back. But we're going to deal with the logistics we have. And I think the solution, if the situation we're confronted with is a group of witnesses who arrive together and are going to leave together and so are housed, if you will, together, is to have the DA make very plain to them that they can talk about anything they want while they're together, other than this case, their expected testimony, their actual testimony, and that's the direction from the court, and we all presume that's followed. Is it? I don't know. You can explore it, but that may be as good as it gets to address your concern. It's a fair concern. I'm not minimizing it. I'm just being realistic about the resources the state has to keep 6 witnesses in different places if they're all going to testify in the course of the same morning.
I understand.
Okay. And I like the notion of let's just keep them in court till they're done, because then they will have testified and they don't go back out. Some of the testimony here may be difficult for some people to hear, and they may not want to be in court for that. So I would never impose a requirement, but it could be they wait outside, but not back in the DA's office where the other witnesses are. We can work through it as we get close to trial. Number 13, excluding testimony regarding the complaining witnesses' truthfulness. There is lots of case law about what can and cannot happen. I'm familiar with some of it because this gets litigated. I've had some cases appealed, and I've been affirmed about how this needs to be navigated. Lay witnesses ought not to be saying, I believe Logan because he's my son. That would be a problem. And Ms. Clark knows it's a problem. That would be more of a blurt. And we need to make sure that that doesn't happen or do our best to preclude it. But there may be witnesses who come in who talk about indicia of reliability or the different ways kids process trauma and disclose, and that it's not uncommon for this, and it's not a sign of coaching, and this and that. And the case law is clear. You may not like it, but the case law is clear that experts can talk about that. And it bumps up against credibility, and that's okay. As long as that witness doesn't say either, and because of all these things, I believe Logan, or you should believe Logan because of all these things. Now, the state will argue that, the state will connect those dots. The witness shouldn't say something like that. But you know, having done cases like this, that there will be a witness the state calls who is qualified to talk about these things, who under almost any circumstance of a child disclosure will be able to say, that's normal. And then there are great ways to cross that. And I've seen it happen. Basically, everything is normal. It can't be that nothing is abnormal, but you manage that how you manage that. But that witness can operate in that space, and that's okay, and I'll allow it. What is not okay, and what I'll seek to exclude, again, assuming there are no blurts, would be a lay witness saying, well, that's my boy, and he doesn't lie. So that's how I intend to handle it, but I want you to make any additional record you want to make now.
Yes, Judge. And so that is correct. Obviously, the kind of more blatant example being, he's my son, he doesn't lie, he's a good kid, those kinds of credibility bolstering statements. As far as the expert witness goes, Judge, of course, right? How I've seen this happen where I think, and you're right, I don't like it, but it is permissible, at least for now, is this kind of thing where here's what my training experience says. These are indications of blah, blah, blah. And then I didn't see these signs of coaching in this particular interview. And it's kind of, here's in a vacuum, and then here's the facts. But what we can't do is, like you said, cross that line into, based on my training experience, he's telling the truth.
Right. It's not ultimate issue, there was a molestation, but it is ultimate issue, you should believe him.
Correct.
That is not what's supposed to happen. That crosses the line, and there is not case law that says that's okay. In fact, it's the reverse. But it's that case law where the expert successfully navigates and establishes both those columns. Here's what training and experience shows. here's what I saw or didn't see in the interview. And then the prosecutor is the one who draws all those lines saying, look, credible, 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 credible. And you do with it as what you can. So that's how I address number 13. And it may get more specific as we get down to the Daubert. But I'm certainly on notice that that's an area of concern. Before I forget, Ms. Clark, was there a forensic interview in this case?
Yes, Your Honor, there was.
Was it performed by the woman in Colorado?
No,
Okay,
it was performed by Leslie Deal.
okay. Who is not in Colorado, unable to travel?
Who's at Showa.
Okay, and is still at, she can be wherever, but
Okay.
she's not medically unavailable for the next 6 months.
Correct, Your Honor.
Okay. Number 14, limiting the state from asking witnesses why a complaining witness would lie. Talk to me about that. I mean, I understand the concept, but sometimes the defense opens the door to those kinds of questions, and it can't be that the state's forbidden to do it, and then the defense can pound on different witnesses, potentially including the complaining witness, about, well, that's a lie, you have all these reasons to lie, and this and that, because there's the other side of whatever that story is.
I agree, Judge. I think if the witness is attacked, then the state can kind of rehabilitate that. If I call you a liar and then they have facts to prove that you're not, I think that's a rehabilitative and would be permissible depending on the circumstance. What we're trying to avoid here is, for instance, why would he come and take the stand and tell all these people, they can argue that in closing,
Sure.
but something along the lines of, you had to do a forensic interview with this child. Why would he subject himself to come and talk to a stranger about sexual assault? Why would he?
Meaning asking the witness that.
Correct.
Okay, I hear you. That's not an appropriate space to operate up front. If it's reactive to something that the defense explored, then, and so I guess my answer is this is context specific. The state shouldn't lead, and by that I don't mean ask a leading question, but be out front with, in your experience, would kids voluntarily come in here and lie? That's asking them to comment, especially if it's, would he voluntarily come in here and lie? Why would he do that? That's argument. So I guess I'm going to acknowledge the concern, but defer any ruling until we get closer to specifics.
Thank you.
We're going to come back to number 15, which is the Daubert motion. Number 16 relates to DFACS records. Do you know that there are DFACS records in this case?
Judge, the department has responded to us that they are, which I was shocked too. It feels like every time I do an in-camera inspection for defects, it's always a different process.
Yeah.
In my practice, I used to skip right to a motion to compel. I would do everything and just with my in-camera, a motion to compel them to do it. I went to Cobb and I've just been there for a little over a year, and they looked like me. I had two heads because they say just send the motion and a subpoena. If they don't give it to the court, then do a motion to compel it. That seems like a huge waste of time, but that's how I've been doing it. And now, even though it's the same agency, that's kind of where we are. I have an order for you to sign so they can produce it.
Okay.
But my understanding based on that response is there are records.
Okay. My experience is what you've experienced in Cobb, which is that you get something to me, or sometimes you can get it straight to the agency. As long as the records are coming to me, the agency will disgorge that. What has changed is the format in which they send it. It up until recently came in an envelope like this, just bigger, 8.5 by 11. But the most recent one, it was an email.
Oh, nice.
It was encrypted and protected and all that, but it was digital, which I assume is easier for them.
I would imagine so.
Yeah. Ms. Clark, are you aware of whether there are DFACS records in this case?
Your Honor, I'm not aware that there are DFACS records, but I will check. I don't see there possibly being any DFACS records in this case.
And you say that because in talking with the family?
Talking with the parents.
Okay.
And just talking with the parents and looking over the case. But I'll put the request in today to confirm that.
Okay. Well, and it may be that what DFACS needs to do is still supply something, and it's a notice of no records, whatever. Let me know, Mr. Denslow, what I can do to assist in getting whatever there is to include simply a notice of no records from DFACS?
Well, I was going to have you sign an order, but I think right now the best way to do it would be I'll hold the order. Ms. Clark can check to see if they exist. And if they don't, then we'll pursue that.
We'll rely on her representation that there are no DFACS records in connection, which would be DFACS's representation to her.
Right.
Okay.
But I would like something, if that's the case, I'm not going to have you sign an order compelling them.
Right.
But I do want a filing from DFACS, something in the record says we don't have this.
Okay. So Ms. Clark, if you don't mind, I'm making a list for you. If you don't mind reaching out to DFACS to see if there are records, and if there aren't, if they could send you something to that effect. And I'm okay, it doesn't even need to be a formal certification. If you get an email from Fred Smith at DFACS or an attorney who handles these things saying there are no records, we can make that part of this record. And that's an agent of DFACS telling you and thus us that there are no records. If there are records, then we need to hop to getting them. Number 17 is a motion to compel the state to disclose evidence favorable to the defense. Ms. Clark, I trust you're aware of your obligations under Brady and Giglio and it's their progeny that you need to disclose a whole lot of things. Top of the list would be anything that is exculpatory or otherwise beneficial to the defense.
Yes, Your Honor.
You're not holding on to any of that as of today.
No, Your Honor.
If something like that comes into your possession, you'll be getting it to Mr. Denslow as quickly as you can.
I will, with all due haste.
All right.
Judge, as to that, we touched on this at the last time I was here, and I did send Ms. Clark an email.
Can you get back to the microphone? It'll just be easier for the court reporter to hear.
Absolutely.
Hold on one sec.
You want me to go close it?
Is that, oh, they closed it.
Oh.
Thank you. I think that was actually in Deputy Gordon's office. It's Friday
I was
party.
saying, nobody should be having this much fun in the courthouse.
Yeah.
But, kidding. And there was two things that we were in particular that we'd asked for. And one of them, what we addressed last time is the state was going to see if they existed. And I just wanted to get an update on that.
Okay.
Actually, really, it's both of them. The crime victim compensation program, if there was any documents or application, I need that as a matter of statute in order to talk to Mr. Gentle about any potential plea offer. It is a statement of the alleged victim or a representative of them. And then two is any other documents, collateral interviews, recorded phone calls that were generated by Leslie Dial or others from the Stephanie V. Blank Center for Safe and Healthy Children in relation to this case. I hadn't received a response. It may be because they don't exist, but I did want to check today. Has that been checked on? Do they exist? And if it does, can I have them?
Okay. Let's start with the first one. Crime victim compensation. You don't know if the family reached out, but if they did, in order to qualify for something, someone would have had to say, here's what happened.
Yes.
Okay. And then second, Leslie Dial, you think is the actual person who would have this?
I believe that is who did the forensic interview in this case.
Oh, Deal.
I'm sorry.
Okay, that's okay. I just want to make sure we're talking about the same people. So you want kind of the case file of Ms. Deal. You have the forensic interview,
Correct.
But if there are other things that she generated in connection with her interview of Logan, you want that.
Correct. And sometimes these are recorded, sometimes they're not. But for instance, sometimes there is a pre-interview interview.
Mm-hmm.
And if there's any recording of that, whether it's a note or an email or a phone call, I'd like to review those. And I think we're entitled to those.
Okay. Ms. Clark, let's start with the crime victim compensation situation. Have you inquired of that organization to see if, does Logan have a last name?
Walling.
Walling. If the Walling family reached out to this organization?
I have not inquired, Your Honor.
Okay, that's going to go on your list. I'm going to send an email out when we're done.
Okay.
With things that I'm expecting the state to tackle. And then in terms of Ms. Deal's, I'm going to call it her case file. I'm sure it has a different name. I know you've provided the forensic interview. Have you checked with Ms. Deal to see what else is in there? A pre-interview, notes, anything like that? And there may be reasons that there are things you don't say that differently. There may be things you believe aren't subject to disclosure, perhaps notes, work product, something like that. But if there's a recording of her interactions with someone, I think that would be harder for you to argue ought not to be disclosed. So I think most important would be for you to let us, meaning Mr. Denslow and myself, know if there is more to Ms. Deal's file than the simple forensic interview. And if the answer is yes, then I guess we need a list of what's in there. Unless you're planning on handing it all over, then it doesn't matter what's in there. Here you go, Mr. Denslow. But if there are things you think don't need to be disclosed, I'll need to know what they are so I can agree or disagree.
Yes, Your Honor. I'll need to check on that, Your Honor.
Yep, it's on your list.
Okay.
All right, so that then, other specifics with your motion 17?
Judge, those are the only two that after we touched on it the first time, those are the only two that came up.
Okay.
That I'm aware of right now.
All right. Number 18, talk to me about irrelevant references to defendant's demeanor.
Okay. So obviously if he takes the stand and testifies, judge, jury, you saw him on the stand, he has no remorse, he doesn't care. You saw him in his interview, there is one, he has no remorse. What is not permissible is that he doesn't take the stand, he's just sitting there and they say, look at this, they can say, look at this child molester, right? That's what they're accusing him of. But his demeanor as the trial proceeds is not evidence. And that's what the 11th Circuit held. So if he, now granted, I'm not concerned that Mr. Gentle is going to laugh or be inappropriate. Of course, I understand the court would probably take care of that very quickly if that occurred.
Well, and if it occurred, I don't think the state's precluded from referring to that. If he had an outburst, if he throws his pen down or something like that. But I'm going to look at not Georgia law, but 11th Circuit law. Let's see if I can find that. It's probably here. Yes. Well, I'll tell you what, I'll take this one under advisement. It's interesting that the 11th Circuit says this. We are not there. So I want to make sure I'm not exceeding the bounds or being bound by something that doesn't bind Georgia courts.
And Judge, I don't, typically we look to the 11th Circuit for guidance on evidentiary matters because we try to match the federal code unless there's a specific difference between state evidence and federal evidence or codes.
Right.
That being said, I would just, as a matter of course, it's also improper character evidence. If he doesn't take the stand saying that he's this or he's that, one, that's not evidence. He's just sitting here. But two, even if it were evidence, it's improper character evidence.
Okay. 19, virtual testimony. The only way a witness from the state could testify virtually would be if you agreed to that. So that would be a case-by-case basis. If the state says, you know what, the records custodian for these records, because we couldn't get a 902 certificate, is in Knoxville, and you may say, I don't mind having the records custodian appear virtually, but there is no default state you can have someone appear virtually. They need to give you and me notice, and more importantly, you would need to concur with that. That's the law. Which is why I asked about whether the forensic interviewer was the person who is in Colorado and has bedeviled a number of cases in this courthouse. So it's granted unless and until we cross a bridge and you withdraw an objection to virtual testimony. I don't think this is this kind of case, Ms. Clark, but there's one exception to that where a child victim is allowed to testify in a way where he and the accused aren't necessarily in the same space, or there are some separations between the two. I've never had to do that with a case here. Are you envisioning this one where Logan's testimony is going to require some type of a comment? How old is he now?
I think he's 9.
He's still a kid. He's not
he's
17 now.
He's still below, young. So whatever, I guess, things that I can do as far as filing during his testimony, I would want to do those things.
Well, there are lots of things that I've seen happen. One is the kid can bring a teddy bear. He's not that young. Sometimes there's been someone who's sort of near the person while it happens. You stand in a particular place that may be a little inconvenient for the defense, but I let that happen. But there's case law that actually allows for something as extreme, and I think that's the right word, where they may not even be in the same room, and that interferes with a right to confront a witness. But there are scenarios where courts have allowed that, but that requires a whole lot of findings and a whole lot of discussion. I don't want to wait until the day he's testifying for us to discover that's how you think it needs to work. So I'm granting the motion that prohibits virtual testimony, but I'm flagging this one carve out that exists. But it would be your job, Ms. Clark, to give me and Mr. Denslow lots of notice if you conclude that when Logan testifies, we need to have, whether it's closed circuit TV, he's testifying literally in an adjacent courtroom where everyone can see him, but he and Mr. Gentle aren't in the same room.
Okay.
I've not ever had to do that. There have been lots of awkward testimonies with little kids, but they've been able to be in the same room with the accused. But with other accommodations, like I said, the teddy bear or it's sort of like a service dog, but it's a human who is right there with the kid when the kid's particularly young. And we need to talk about that too before it happens. I'm not giving blanket approval to any approach, but if this is going to trial, and that's a ways away, just be thinking about how you and the victim advocate will be navigating things with Logan when he testifies and what that's going to look like. Because the time to talk about it isn't, oh, our next witness is Logan Walling, and he's going to sit in his mom's lap. That may be okay, but only after we talk about that for a while outside the presence of the jury. And if he's that big, that would be weird. So hopefully that's not what happens. But I didn't go through what he went through. So that's how we're handling 1920, preliminary charge to the veneer. Tell me what that is. Oh, I think that's your request that I give them certain charge. We'll talk about that before we do voir dire. I talked to the jurors about the burden of proof. Well, to the 51 or however many we have to pick a jury, I talked to them about the fact that, the indictment is proof of nothing and that your client has the presumption of innocence that stays with him throughout the proceedings, and the state has the burden to prove his guilt if they can beyond a reasonable doubt. The burden never shifts. I say that. I don't get into lots of other things other than what voir dire is about and why we're here this morning.
Judge, obviously, I don't know what exactly that looks like, but from what you're telling me, that alleviates any concern I have, because this kind of goes hand in hand with the statutory questions motion. Yeah. So we can deal with that later.
We will. I don't think you're going to be shocked or appalled by the presentation that I give. It's just not something that I'm going to print out and give to you or to the jurors, but it covers that important concept, so they understand. Well, they hear it. They may not understand it, and that's what you explore during voir dire. Like, well, yeah, it's good until it's your turn to prove his innocence. Like, oh, okay, that's not. You didn't get it. Yes, you can file additional motions if there are any conceivable additional motions. And Ms. Clark, you're aware of your ongoing obligation to supplement discovery as you get things. What's in the hopper? Are there things that you don't have? It sounds like maybe with this other act in Glenn County, you may be trying to get some information. You'll have a little bit of homework flowing from today. But are there other pending, anything from the GBI that's sitting there, or things that you want to get for your case that will be discoverable that Mr. Denslow doesn't have yet?
Not right now, Your Honor, because the the forensic interview and, but as I I'm going to be starting my witness interviews with my different professional witnesses on this case next week. So if there's something that is brought up or something that is used, of course, I would want to turn that over.
When you say professional witnesses, that would mean a doctor or
Doctor, forensic interviewer, social worker, anybody that I guess interacted with Logan.
okay, who's not a parent, friend, relative, whatever. It would
Yes,
be they were strangers to him initially and they were interacting with him in their professional capacity.
Correct.
Got it. Okay.
And just out of abundance of caution on my end, Judge, and if you can tell by how I've been operating, there's a lot of caution on my end of the table. When we say that's going to be turned over, I mean, is that a recorded conversation? Like or is it just that, hey, I had another conversation, here's a writing of what was discussed. I just want a little bit more specificity.
I understood Ms. Clark to say when she interacts with them, she may learn that they have other things in their case file and you'd get that.
Okay.
It would be a new thing to me if you received a recording of whatever conversation Ms. Clark had with that witness. Witness prep, in my experience, presiding over district attorney cases has not involved getting a recorded statement from the professional witnesses. It might from a recalcitrant witness, like, well, we better record this because I don't know what it's going to be like when you testify.
Right.
That you'd get. But I sat down with Dr. So-and-so. Is this what the medical records mean? And blah, blah, blah. That's their work product. I haven't seen things flow from that to the defense.
And I would agree with that, Judge. And I think also there's a difference between the professional witness and the not one, the lay witness, I should say. And I guess there has been some issues in the past where the district attorney actually makes themselves a witness when I am the only one in the room with this complaining witness, alleged victim, and there's a new disclosure where there's a whole different incident that comes up. She's then made herself a witness that I can't call.
You're right, which is why I bet Ms. Clark would tell you she wouldn't interview any of these folks by herself. There'll be an investigator there as well. That's also been my experience.
The other problem with that is sometimes who is there is a victim witness advocate. And so when I try to get those things, I'm met with a lot of resistance because much of that is supposed to be confidential and I have to pierce this veil. So I just want to put that on the radar.
Okay, it's on the radar. If you are told that you're not able to get to anyone who was involved in that interview, then there's an issue. Because then you may well have, the state may well have created a witness out of the prosecutor. But my experience is that they structure these things so that that's not what happens.
And I appreciate that.
Me too. So that leaves us with number 23, which relates to child hearsay and then the Daubert motion. And I think I wasn't planning on going over all of these, but it was efficient and I'm glad we did because some of them we revisit when it comes time for voir dire, and some of them I've invited you to particularize as you learn more about the case and shape your defense more because we may need to revisit them. But I think I'm going to do some homework on your number 18, which is this 11th Circuit references to defendants in court demeanor. And then we need to talk a little bit about Daubert and child hearsay. I want to call up the child hearsay motion.
The emergency motion.
I don't know. I'm gonna wait and see what the judge says.
So your final motion on your roster, number 23, objects to child hearsay statements. Is it that you object unless the Logan testifies?
Essentially, Judge, I mean,
It's
yes.
follow the rule is the request?
Well, actually, the rules that I have to object.
Oh, no, you do, but the objection is, hey, none of this can come in, should come in, unless, of course, Logan's going to testify.
I mean, do I have problems with the child hearsay statute? Yes. Is that what the law is? Yes.
Right, that you take to the Gold Dome, not to me.
Correct. Well, or at some level, I guess the court above, but
Right,
the issue
it's withstood a few challenges, the child hearsay statute.
It has. And I'll keep challenging it.
That's why Mr. Gentle pays you. So it sounds like, Ms. Clark, you have no intention of skirting your obligation of having Logan testify. So
No, Your Honor. In
Okay.
fact, the state intends for Logan to testify.
Okay. Have you provided yet your notice of child hearsay so that Mr. Denslow knows which witnesses will be?
There was one filed when we served discovery, Your Honor, but the more particularized one, I'll work on getting that one done.
All right. When you provided discovery, did it simply say, hey, we're going to be calling witnesses who talk about Logan's disclosure, or it said, here are the witnesses?
It's just that the state will be
Invoking 820.
child hearsay based off of the victim. I'm paraphrasing.
That's
but,
fine.
yeah.
But it doesn't get into here are the witnesses who will be. So that's an obligation you've got
So I
would
need
be,
to work on
right.
that.
I mean, our trial calendar call is June 12th.
Okay.
That's not the date of trial, and this isn't the only case on the calendar. But that notice should be going out soon.
Okay.
That says, here are the witnesses that we expect will be talking about things Logan said to them.
And Judge, I may be wrong on this, but I guess depends on how voluminous the record is, but is it not just the witness, but also the specific hearsay they intend to introduce? Like Logan told witness A this.
Yes, but it is. It's not just Fred Jones is going to come in and talk about things Logan said. But I have seen notices that I deem sufficient where it said Fred Smith is going to talk about the disclosure Logan made. And it's not a verbatim because we don't know what the verbatim is. And maybe it's a little bit more than that, but there's not things in quotes because we don't know exactly how Fred Smith will talk about it. And when you get the disclosure, if it leaves you wondering what's really going to happen here, we should talk about that. But I don't believe that the disclosure requirements require a hearing where Fred Smith has to come in and say in advance, this is what I'm going to say Logan said to me. One, Fred Smith in theory is available for you to interview. If he doesn't want to talk to you, he doesn't. You explore that on cross-examination. But B, it's more so letting you know in advance, this is someone who is going to be called upon to provide hearsay testimony that is accepted, that's EXC, through 820.
Judge, and I get that 100%. I agree. The issue though too is, for instance, not the verbatim statement, because I agree. Sometimes we don't know.
Right.
You know? However, like Miss Deal, the statement that was given to Miss Deal during the forensic interview, or that was on or about this date, because then, for instance, if we have a situation where even the state's not aware, the witness says, "Oh, and again, 2 months later, he said
Right.
so and so."
No. That's it. May be that it needs to be anchored to this was the disclosure he gave the day of, and witnesses. I don't remember when the alleged conduct occurred, but the further back in time it is, witnesses are going to say, "I don't know. I know it wasn't the day he told his mom. It was 2 days later."
Right.
But they need to connect it as best they can, either to other disclosures or to the date of the alleged conduct, if it's 1 day, or there's something people are going to remember. If they're going to remember that Logan said this to them, they'll remember, man, I remember it was the day he had to come home from school early. And you're entitled to that basic context for two reasons. One, notice, but two, so we all know that's what you were notified about. So if this witness said, oh, and there's this other thing, wait a minute, no one told us about that. And that might be appropriately excludable on notice grounds, which is an 820 ground, but it's not because it wouldn't be accepted from hearsay restrictions. It's that the state didn't flag it. And they may have not known that there was this second disclosure because it didn't come out in their interview with the person. But if there were multiple times Logan disclosed to this person, it should be indicated that this person's going to talk about multiple interactions they had with Logan about this, and not Logan disclosed to this person, because that's not sufficient.
Thank you, Judge.
I assume you were listening to all that, Ms. Clark.
Yes, Your Honor.
Good. So does that address the objection to the hearsay statement? It's that you are, one, preserving any and all objections to the whole concept of 820. But right now it hasn't been noticed with sufficient particularity.
Correct.
Okay. We'll revisit this as necessary. I intend to admit child hearsay, the disclosure of which that has complied with 820. That's my ruling, because I'll follow the law. But we're not at that point yet because there has not been a sufficient disclosure. I just noticed you filed a demurrer.
Yes.
And we're supposed to talk about that. So let me pull up the indictment. Okay. Why don't you tell me, Mr. Denslow, if this is a special or a general demurrer or both, and if so, why? I just reviewed the indictment again and I'm ready to try to follow what the concern is here.
Yes, Judge, it is both. So as to count one, there's no definition of the term sex organ under the statute, nor is there one on the face of the indictment. So because of that, we don't have a great opportunity to intelligently prepare a defense when we don't know what he's alleged to have touched. Of course, his actual knowledge of the events is irrelevant to the indictment. So it's unconstitutionally vague is the argument for count one, the blanket term of sex organ.
Okay, we've, I think, established Logan is male. Yes?
Yes, Your Honor.
Okay, all right. So that's a concern about count one. Is it a concern about the same language is used in count two? It's just the other party's sex organ.
Correct.
It's not defined, but is the same concern about count two?
Correct.
All right. What other Demurrer-esque concerns are there?
Right. And then if we go to back to count two, there's a general demurrer. The first two were special demurrers to count one. Count two, there's a general demurrer. There's language of the statute. If an accused, or sorry, the language of the statute or of the, goodness gracious, of the indictment did that Mr. Gentle is accused of unlawfully committing an immoral and indecent act to with and in the presence of Logan Walling, a child under the age of 16 years, by causing such child to touch the sex organ of sex accused.
Mm-hmm.
So I understand, Judge, that this may be me nitpicking, but the word used by the legislature is perfect in form and in substance. This is not. It's obviously a typo, but it is nonsensical.
Okay. And I will look this up, but I hope you have already. When there is an obvious typo and it won't leave a jury or a defendant confused, does the case law say that doesn't require a fix because it was I don't want to call it a Scrivener's error. It just, someone was sloppy and didn't proofread it. But it would be one thing if it said a child under the age of 18 years and it was written 18 and the numbers are in there. Like the law doesn't say that. And so a jury could look at this and Logan's 17. Great, he's guilty of child molestation. That's an error. Here, it's an error. But when I read that, I saw it like, that's dumb that they didn't catch it and fix it. But I have no question what the allegation is or what the state needs to prove.
And Judge, I might agree with you on a special demurrer. This is a general demurrer, which says that I could admit to all the facts in the indictment, which has to be specified, has to track the statute. Mm-hmm. He can admit to it's nonsense. It's nonsensical and it's not a crime. And also, Judge, You're obviously a well-versed jurist. The jury is not. So it may be apparent to us that this, what the statute says and what it's supposed to say, it is not to the jury.
Okay. All right, so special demurrer, both counts, because sex organ is not defined. And then general demurrer, count 2, because it says touch the sex organ of sex accused rather than the accused. Got
I
it.
think what they were going for was said accused.
Or said accused. Yeah, because it was said child above. Either way, it's not the right word for the or said.
God knows I have committed a typo, and probably in some of these 23 motions I put before the court, unfortunately, but it's different when it's an indictment.
Right. The gravity and impact of your motion, while important, is different from the charging document that the jury would be considering. Ms. Clark, what are your thoughts about these demurrers?
So the state acknowledges that the word sex accused before shouldn't have been there, Your Honor. But I think that the argument on a general demurrer fails because of the fact that the substance of the indictment does, articulate the law itself, and it puts the defendant on notice as far as what he's been charged with. So I don't see, how that.
So the special demurrer says basically, I don't know how to defend against this case. It's not specific enough.
Right.
The general demurrer, that test is, I could admit to this, and I walk in front of a jury and say, I did what's listed in this indictment, and the judge is going to tell you that's not a crime.
Right.
The general demurrer to count 2 is a little funky in that way, because I wouldn't be admitting to any of those words in there thinking that it would go well for me. But the word sex is a freighted term in that allegation, and it got put in a second place in a way that is murky and nonsensical. And so I'm going to look at case law, because I am sure probably not this exact mistake has occurred before, but something where we know what was meant here, but that's not how it was typed out. And the courts may have said, it's fascinating that lawyers know, but it's what a jury would do with a document that the judge says, this is the charging document, and it goes back with the jury. So what about the special demurrer, where it is not specified what specifically was touched?
I definitely don't agree with that. In this case, a special demurrer, the language doesn't have to be, perfect, but it follows the statute. It tells what child molestation, the sex organ. Logan is a male. The defendant in this case is a male. I just don't see, other than a pattern, a non-pattern charge, basically with how sex organ is defined at trial, but I don't see anything wrong with it as written.
Okay. Well, I will take this one under advisement. It's one I want to rule on quickly, because if you're going to need to re-indict, it's going to change the functional landscape, not at all. So I'm not worried about delay, but Mr. Denslow is correct. If he's correct, these need to be fixed. And it's a quashal. They only get so many. So there's value to that and to the defense. And frankly, if I conclude legally it's murky or insufficient, then we ought to clear that up, because then we're removing an area of confusion that the jury ought not to have to navigate.
Judge, if I may just briefly respond to the state's argument as to the special demurrer. We oftentimes have to talk about awkward things. This is about a child sex case. So, I guess I'll rip the Band-Aid off. I know it seems silly, right? Because Logan is a male. However, it is about, when it comes to a special indictment, can the person of average intelligence discern what is being said. Not a legal jurist, not somebody who knows what the code section is saying. Again, the code section is silent as to that. But in 2025, and for really since the beginning of time, males have more than one organ that could be used for sex. So it is not quite as clear cut as I think it's been stated. And given that the amount of cases I've dealt with where the mouth, the anus, the vagina, the penis, it is vague.
I'm not disagreeing on either front that it's stuff people don't want to talk about in a setting like a courtroom, but also it could lend itself to some confusion. I'm going to look back at the statute. I know it's more complicated and specificity is expected more when you deal with females, just from the statute. And I think that it's even plural. It's not, I think it's referred to as the sex organ of the male, but then there's sex organs of females and this and that. And so it needs to be right. I'm not pushing back in either direction. It needs to be right. And I will look at, I'd be surprised if, well, I'll see what's in the case law. And I'll be educated by what's in the case law. So Demurrer, I take under advisement.
Okay.
The Daubert motion. I'm not required to have a hearing. Talk to me about your concerns, and then why you think I need to have a hearing on it. We're dealing with what I would, well, take a step back. Your motion is a Daubert hearing challenging the forensic interview, not if a doctor comes in to say that this is what I found medically when I examined Logan. So we're dealing with the expert who would be more of what I call an educational expert than a technical expert about the tensile strength of steel where you can recreate this. And if you crash a car into a wall going 100 miles an hour, this same thing will happen every time because here are the crumple factors for automotive steel. We're dealing with a witness who is going to be talking about ranges and averages and experiential learning. I've done this 1,000 times. No one reacts the same way when disclosing that kind of thing. That to me lends itself less to some of the rigors of what one would do in a Daubert hearing. But I want to understand what your concerns are, because it's not going to be a battle of the experts in this sense. You may call your own expert. That's not my point. But there's not going to be an expert who's going to come in and say, Ms. Deal got it wrong. That wasn't a disclosure. I mean, it was a disclosure. And people can say, here's where I saw coaching. Here's where I didn't see coaching. Those experts can differ on that, but it's not one where mathematically you're going to show that's bad science. And the science that needs to be applied is this, and this person didn't do it. They used the wrong reagent. So of course they got that result. It is a softer science or a softer field even. So that's not to say the motion is misplaced. I just think the way we work through the motion is different than if you were challenging the DNA results. Having given that preface, talk to me about your Daubert motion.
Judge, while I agree with the court as to the practical distinction between someone to come and talk about how to mix concrete or the actual hard science versus what's going to come, what the state's going to offer to this jury, the law doesn't differentiate between those two things. If you're declared an expert, you're declared an expert. And to be declared an expert, you have to do two things. You have to employ a reliable methodology, and you have to apply that methodology correctly. We're really talking more about prong two, right? I think that I lose that argument about whether or not child first or this particular type of a forensic interview is widely accepted in the community. It is. It's peer reviewed, that kind of thing.
Right.
The issue is you could be a great engineer, but still mess something up. So this is about the application of that methodology and the required, what I typically do is we have that person come here, we all watch the interview together, they direct, I cross about how did you apply child first? Did you do it correctly? And so that is kind of what I was getting at today, is the application of that.
You've reviewed the forensic interview?
I have, Judge. I'm not prepared right now to tell you every issue I have with it, but typically there are, and this usually the response is there's no such thing as a perfect interview, right?
Right.
But sometimes there's leading questions, or they give them an array of options rather than asking open-ended. They talk about how you'll never get in trouble for anything you say here, but also tell them to tell the truth. And if I'm not going to get in trouble, and some of that's for cross-examination, I get that.
Right.
But at some point, we deviate so far from the methodology that we can't say that I've followed it. And if you haven't followed it, you can't testify to it. So that's kind of the issue I have there. And I apologize, Judge, that I did anticipate that I'd kind of be able to watch the interview and cross them and direct them. And so I'm not as prepared as I should be today. But that would be what I was aiming for.
Okay. So your vision is, how long is the interview?
Gosh. It's probably about an hour, an hour or less. It's not a particularly long one, if I recall.
All right. And so your vision for the Daubert hearing is we basically look at the work of the expert, which is the interview, and I guess Ms. Clark establishes what the methodology is, and it sounds like your pushback's not the methodology, assuming this expert can articulate it. If she can't, then that's another area of exploration that might be fruitful for you. But if she says, this is child first, this is my understanding of it, that's what I did, it's turning to, okay, is that what you did? Press play. And we go through that. And I guess Ms. Clark can highlight areas where it's happening, and then when you cross, you highlight the areas where you think it didn't happen, and then I'm assessing writ large. Yeah, there were a couple bumps in the road. You're not supposed to lead, but kids can take you to a space where it's just the only way to keep going is to ask a question that is somewhat leading. That may be the conclusion of the interviewer or something.
And Judge, the only other thing would be, insofar as the methodology itself, I think that it has been held time and time again that it is a reliable and accepted methodology. Again, I disagree with that. And for instance, there's toxic tort cases, and I know it's a bit of a stretch, but when it talks about and we talked about this earlier, right? It was kind of in jest, but if every stimuli I add to the scientific process leads to the same result, we can't call that science. We can't call it science.
But this is the reason why I started our conversation the way I did. And I say this not to minimize the importance of the professionalism involved, the trainings required, but it is not the kind of science that the Daubert standard was designed for. I always fall back to two scenarios. I had one in cases that I had to try a couple times where you bring in someone who is an expert on Islamic jihad, especially online inculcation of jihadist thinking. And there are experts in that, and that they know more about it because they can read Arabic, they know where to look online, they have created online personas so they can get into chat groups that you and I couldn't. And they come in and they educate a jury about it. There's not a whole lot of science behind it. It requires Arabic. It requires understanding some of the tenets of Islam. It requires understanding how some of those have been applied in a way that endorses violence against infidels. And then you are able to say, here's this website, and it's all in Arabic. Here's what this means, and here's how you'd get into it, and here's how you gain stature. How could you become a moderator on this website? You need to write your own articles. And here's an article I found written by that defendant right there, and here's what it says. And that's an expert, and that person was qualified as an expert, but what's the methodology and what's the science, and could you recreate it? I guess with a similar website. That's not this. This is more rigorous than that. Not that that wasn't rigorous and that expert knew a whole lot, but he was no less of an expert than a cardiac surgeon who comes in to say that stent was no good, and here's why the stent's no good. That cardiac surgeon and the stent not being good, that's hard science, or like how to make the right cement so that the bridge doesn't collapse. This is way on the other end of the spectrum where, yes, there's a methodology, but even the child first, it's not so rigid that it's this baking mold into which you pour. It has tenets, and you should try to do X, but you're dealing with a kid, and you may vary from that, and you know that the experts will say that doesn't make it a bad interview. That's just a reason to be concerned about that part of the interview, which goes to the weight of it. I understand that's not what the 702 test is about. It's not about weight, and a judge should not say, we'll just let the jury worry about it. It's a gatekeeping. It comes in or it doesn't under 702. And if there wasn't a correct application of the methodology involved, then it doesn't come in. And I think the way we sort this out is by looking at the video. My concern is we're creating a record for a witness where you haven't articulated in advance. I can point you to where there are deviations from the child first model, and they are powerfully impactful deviations. I made that phrase up. That's not a test. It's not a requirement, but I'm confident that you, with your skill set, could watch that hour interview and find at least a dozen instances where it wasn't hardcore compliance with child first. That's not going to exclude it under 702. But if you found situations where it's leading question after leading question to, but you did this, didn't you? And then you did this, and that's when he touched you. And it's the heart of the disclosure that is not consistent with any, even the most elastic application of child first. I don't get the sense that that's what this interview is, because that's not how you wrote your motion. And so I just want to be mindful of not abusing the 702 process to create a transcript of Ms. Deal's testimony. There is additional gatekeeping, my gatekeeping to exclude bad science, quackery from the jury, but there's also the gatekeeping of we don't have a Daubert hearing just because a methodology was applied in a situation.
Okay. If the court would like, I can file a particularized motion before we go forward. I can do that. Insofar as what we discussed with the, get to the mic. I'm a pacer if you can't tell. So again, there's this kind of practical distinction between experts, but that 702 to determine the admissibility of expert evidence, not practical expert evidence versus soft science, any expert evidence. So Judge, I agree with you that this isn't science. And if it's not, they shouldn't be declared an expert. However, there's another way the state can still ask them for an opinion based on their training, experience, specialized. I think it's 709. I'd have to look at it again. But where you can have not necessarily a lay witness, but where even a lay witness, I use this for a law enforcement officer in my last trial. Said, you've been a law enforcement officer for 20 years. You've responded to lots of accidents. You know what darkness looks like at night. Do you think that he could have seen this pedestrian on the roadway? Probably not. That was objected to by the state and overruled based on exactly what we're talking about. So if you and I agree that this isn't hard science, that's what 702 says it has to be.
Okay. So I'm going to take you up on your invitation or your offer and ask you to particularize the Daubert motion.
And I'll do both, Judge. I'll go through the video and review that. And that's a better course of action anyway. I should have done that already. But I'll do that part, and then I will kind of clean up this methodology argument in general, and I'll submit that.
Okay. I'm more focused on the former than the latter. I think your methodology argument is clear and correct. I need more in your motion to show that it wasn't correctly applied. You mentioned it's good methodology, proper application thereof. And your focus was number 2, because the case law is out there that it's an accepted methodology, meaning it's an accepted science, lowercase s science. And so what we would be discussing if we had a hearing would be Ms. Deal's application of that methodology. And so that's what your motion needs to highlight. And I encourage you, if you watch it again, and this time with an eye to that one, to take a step back afterwards and say, was that enough? Because you will identify some things, but as you look at that, is that enough to say we need a Daubert motion? Because if you're not persuading yourself that that's enough, then yes, again, you can say, right there, that was a leading question, but writ large, pretty compliant with the methodology, then we ought not to have the hearing. But you are that gatekeeper. I'm not. So you're going to file what you file. I just encourage you to apply that screen to it. Different things where she slipped a little bit.
Yeah, the only other thing is, obviously, we've been making a lot of assumptions that it is child first that was applied. So I do need to know that.
You're not bound by anything you said today other than that you will particularize the motion.
Well, but I'll go back and review the report, but usually they don't put in the report which methodology they're applying. So that is another reason why I usually do have a hearing, because
to learn that.
To ask you, what did you apply? I can reach out to Ms. Deal, but that may be something we have to take up.
Okay. Let's sort that out in advance so you know what you're analyzing. Because if she used child second, then she may have complied with it really well. You'll be, oh man, look at that. That's not good with child first. Well, I didn't use child first. That's yesterday's methodology.
Right.
We've learned that it's time to put the interviewer first and the child second. And we see where that gets us. And if you have any trouble connecting with Ms. Deal in that way, not that she would be inaccessible, but she might say, I would hope that she would talk with you freely. But if she doesn't, then let's loop Ms. Clark in, because I would love to short circuit or at least streamline that first part so that you know what tool set she believes she was applying to the interview.
And this may be resolved too. I haven't received her resume.
Okay.
I was mess up the Latin, so we'll keep it with resume.
Yeah.
I have not received that. Sometimes if it only has one that they've done, then I know which one it is, and we're done.
It better be. Yeah. Okay. I'm going to add that to Ms. Clark's list. Deal CV.
Your Honor, if I may add though,
Please.
The forensic interview is not in and of itself expert testimony. The forensic interview is actually an out-of-court statement that would come in under 820. And also, there is a case, State v. Dickerson, that is 2018 Kansas APP, but it's unpublished. Lexus 860. It's a 2018 case.
Not an unpublished case from Kansas. I'll tell you, 11th Circuit, it's a little more compelling than this, but I'm listening.
But it does say, I know but it says a lot. It says reasoning that because forensic interviews are not expert testimony, the panel need not address whether they meet the requirements of Daubert. The Georgia Hearsay statute allows for the recording or the transcript to come in under Smith v. State, 361 Georgia APP 436, and Sean v. State, as well as Robinson v. State, 342 Georgia APP 624 on page 629. It's a 2017 case.
Okay, well, I didn't hear Mr. Denslow saying that the interview itself wouldn't come in. It would be the narration that Ms. Deal provides during her testimony, and in particular, that she be qualified as an expert as opposed to a Rule 709, if that's the rule. I'm going to need to look at that because I'm liking that as an option, not necessarily for this, but some of our law enforcement folks who come in and talk about things that they clearly know that other people don't, but to call them an expert is a little funky because it's pretty far away from science. It's just, I know and you don't. And they ought to be able to offer an opinion in connection with what they know and you don't. But I was not ever thinking that the interview doesn't come in.
Okay.
I was thinking through, and what I thought the motion was pushing back on, does Ms. Deal get to say, here's why I don't feel like he was coached before he came to me because, or his answers weren't, you would be asking her to talk about, do you find that when you do these interviews that you're providing the answers? No, I use child first. And you can see in this interview, I use child first. And you want the patina of expert around everything she says, so you can argue in closing. And you heard from the expert, this was a good interview, as opposed to the interview comes in, it's his disclosure under 820, but it doesn't have that little gold seal of approval. Ms. Deal, the expert, said this was an okay interview, this is how kids react, etc. I hear Dickerson all the way from Kansas, but I wasn't thinking the interview was at risk because of this Daubert motion. That would come in and it would be given the weight the jury ought to based on a cross-examination of it was leading and you drew the diagram and pointed an arrow towards the sex organ, and only then Logan said, sure, okay, that's where he touched me. That's his disclosure in the for what it's worth category. That's not a good interview. I bet that's not what happened. But if Ms. Deal is going to talk about, and she would never say it this way, but it's what you'd want it to come across as, here's how great my interview was. It's all the greater if she's an expert when she did it. So I don't mean to speak for Mr. Denslow, but I don't want you to be worrying about, dang, is the judge going to keep the interview out? That's not what I think is on the table.
Yeah, would she be an expert and would she be able to offer an opinion?
Right. All right, we are about out of time. I want to make sure we cover everything we need to. There was a motion to quash that the state filed, but before we turn to that super briefly, was there anything we didn't cover that you were hoping we would cover?
You asked me to file a motion to, we didn't ask me, you had brought to my attention that he's still wearing the ankle monitor and the county's paying for it.
Okay.
And he's been in compliance. So I did file a motion to modify the bond conditions.
Okay.
The other one is I filed a motion for a continuance.
Okay.
And which one would you like to start with?
The continuance.
Okay. Judge, my client, Mr. Gentle, suffers from dementia. So when we left court last time, I was walking out in the parking lot with him. He let me know that he has a heart procedure. The same, make sure I have the date right, June 13th.
Okay.
It has been scheduled. Because of the dementia diagnosis, I had him go to the doctor and get me a letter, which he did, and I received it. There is a heart procedure scheduled for that date. So we were asking to continue him off of the June trial week so that he has time to recover from that procedure.
Is there medical information I can get about the expected time for recovery?
I can get that to you, Judge, yes.
That's what I would need. I hope the heart procedure goes well, but if the doctor says he should be able to interact as well as someone with dementia can interact with his lawyer 24 hours later, our trial calendar it's a couple weeks after the call of the calendar. I certainly would excuse Mr. Gentle from the call of the calendar, although that's the day before the procedure. So that should be less necessary. But we need to hear from the medical professionals about the recovery window.
And counter call, you said the day before, that'd be the 12th? Or sorry, the 14th?
No, so June 12th is when we call this trial calendar. You said the procedure's on the 13th. I'm not seeing a conflict there. The trial itself will start June 23rd.
Got it.
That may still be way too close, given the recovery, but I don't know. I have a kid with a pacemaker, and when certain things happen, he's out for a while. Other times, real soon thereafter, he can be up and at 'em.
I'll find out.
But very different age from Mr. Gentle. So.
Correct.
Ms. Clark, the ankle monitor, did you have any interaction with the family to see if they had a concern? We have a defendant who it seems like is going to stay away, and I don't think he's a flight risk. That's not my concern. It would just be maintaining an appropriate buffer between the Walling family and Mr. Gentle.
So the Walling family has expressed a concern about, they do not believe that the ankle monitor should be removed. And the state agrees, especially with the personal disclosure about the defendant having dementia. We just don't want to make sure that because of complications or whatever, that he may wander into a place that he is not supposed to. That would pierce the barrier that has been put there for him not to have any contact with the Wallings.
What is his connection allegedly with the Walling family? Are they related? Where they go to the same church? Is it educational?
Yes. So so Jessica Walling, the mother of Logan, is her mother. He's married to Jessica's mom.
This is step grandfather of Logan.
Correct.
Okay, got it. And Mr. Gentle is still married to mom's mom.
Correct.
Okay, so there is a direct familial connection. I mean, it's by marriage, but it's not that he lives 8 towns away and there's no reason anyone would ever be in the same space.
Right.
Okay, all right. I will take the ankle monitor request under advisement. You will, you have 2 due outs. One is to particularize the Daubert, and 2 is to get me information from the doctor about recovery period.
May I speak on the bond modification briefly?
Was there more than the ankle monitor?
Well, no, but my response to the state's argument as to why the ankle monitor should stay on.
You can for 30 seconds.
Great, because that's all it's going to take.
Okay.
He's been on bond since September 12th, 2023. An ankle monitor does.
Oh, 23. Okay, so this just took a long time to indict.
I mean, I'm going off my motion. Let me make sure.
No, I'm not doubting you. Oh, I see it right here. The bond was September of 23. And he posted it on or before the 28th. So, we're 20 months in.
If his dementia was going to be the issue, Judge, that the ankle monitor is not going to stop that, he would have wandered in by now.
Okay.
That's all.
Okay.
The state did file a motion to quash. I don't know if we want to take that up today. We're maybe out of time.
Quash what? I read it once, but I'm not remembering, Ms. Clark. Oh, is it like school records or something?
Yes. So, defense has filed, sent a subpoena to Logan's school and, requesting his records. And we're wanting to quash that subpoena. But we don't see that there be any basis to obtain the records. But if the court, does do so, we would want the records to be sent to you and those reviewed by you. If there is something that is exculpatory,
let's do it that way.
Yeah.
I think I don't want to close a door, but same with DFACs. Have the records sent to me. And if there are any, they should come to me, and then I'll review them. And if I think there's something that's germane, I may just provide a general descriptor of what's there because I may not fully understand what's germane to the defense. But let's start by having it go to me.
Judge,
so Your Honor, is it possible for me, as far as on my to-do list, we can request that the records from the school go directly to you?
Well, let me hear from Mr. Denslow because he didn't like that idea. I want to hear why, and may have a different plan.
I object, Judge. There's nothing that says I can't subpoena these records directly. There's not any authority the state cited that says my subpoena is unlawful. Why can't I have it?
What if he's talking to a counselor and it is student counselor protected?
So I addressed that in my response motion.
Okay.
But I went to, insofar as their staff website, they don't seem to employ anybody of that nature. If the state is saying that exists, then I will change my position. But as of now, there's no evidence of that. Further, we could
But
redact.
wouldn't you know only because they gave it to you and they shouldn't?
Well, if there is someone from the school who says this person's a counselor and he's disclosed reports of child abuse.
What do you expect you're going to find? You're poking around in a kid's school records. What is it that you think is in there?
Judge, I'm more than willing to have that discussion with you ex parte, but I'm not willing to sacrifice my ability to prepare my defense in secret.
Okay. That's a fair request. I need to read the response to the subpoena, and then I will let you all know how I'm going to proceed, and we may need to have more discussion about it. Ms. Clark, I'm going to send an email to, well, both of you, I'm going to send an email out. There are 2 things Mr. Denslow is going to be working on. I got 5 for you, Ms. Clark. And we're going to want to focus on them unless I'm continuing the case. Because if I'm not continuing the case, we could reach it the week of the 23rd. Now, full disclosure, I got older murder cases with defendants who are in jail. They would likely take precedence over Mr. Gentle's case. But Mr. Gentle is not getting younger and more focused and able to assist his attorney. So there is a different type of clock ticking on this one that I think is important to keep in mind.
Your Honor, I also want to, in my motion to quash, School records, I mean, it's case precedent that a defendant may not seek to utilize school records unless the records directly relate to the allegations of abuse. That's in Lively v. State.
But utilize and obtain are two different verbs. And so I didn't do my homework on this. So I'm going to read the cases, and I also didn't know there was a response to the quashal because I didn't look, but there is. So I'm going to read the response. And like I said, if I need more input from you all, I'll reach out. If it's just not fruitful to have an email exchange and we need to have a mini hearing, we'll do that. But we've covered lots of ground, which has been very helpful. We are time limited. So
Would you like a copy of that,
of what?
of my response?
Did you?
It's filed and it was sent.
Okay, if it's in the docket, I'm good.
Okay.
There's your response, May 5th. Excellent. Mr. Gentle, you doing okay?
Yes, sir.
Good.